back, ladies and gentlemen, to the second session post-lunch. And this session is about the latest developments in Indian taxation, practical controversies, and cross-border issues. I would like to call on the chair, Mr. Raman Chopra, who is Joint Secretary, Tax Policy and Legislation, Department of Revenue, Government of India. And he will call on the panelists himself. Mr. Raman Chopra, can I have you up on stage, please? Thank you. Please give him a big hand, ladies and gentlemen. Thank you.
Good afternoon. Post-lunch is a difficult time for the presenters as well as the hearers. And I'm Raman Chopra, Joint Secretary, Tax Policy. And in the first session, it came up a couple of times that I'm speaking here. Any government official who appears in any conference speaks on his own behalf. It is not speaking for the government. But there is an important other side to this statement. When he's hearing on behalf of the government. And that is most critical. That is why I am here, in fact. I'm here more to hear everybody, all sessions, not this session, my panelists, the earlier panelists, the panelists coming after us. Government wants to know the perspective of the stakeholders. That has been the focus of this government throughout the last 10 years. And in fact, if you pick up the first speech of the finance minister after the government came into power in 2014, it talked about ease of living. That quickly changed to ease of doing business. And tax administration fundamentally is a subset government administration. And our focus principally has always been in the last 7, 8, 10 years to reduce any difficulty arising to the stakeholder. That is the environment we are wanting to build up. I don't know how successful we become in that endeavor, but that is where we are going. And ease of business, if you see, has two components. For any business, the interaction with the tax man is not anticipated to be comfortable. So one part of the ease is fundamentally not being intrusive. If the stakeholder is told that the government is not intrusive, that half the problem related to ease of business is sorted out. And if you see, the cornerstone of government policy is non-intrusive voluntary compliance. And how was that enabled? It has been enabled through digitalization, through information gathering. And it has been all done to actually induce foreign investment, foreign entities coming into India on an easier basis, on a smoother basis. There have been specific incentives for that. And this voluntary compliance was aided by third-party data collection. The second part of ease of doing business was certainty in taxation. If the stakeholder or the business can have a certainty on what tax he has to pay, his business is easier. And that certainty, how does that certainty come? Certainty is fundamentally driven by interpretation. Interpretation is judicial interpretation or a legislative interpretation. And unfortunately, in our country, judicial interpretation takes a lot of time. So, judicial interpretation taking a lot of time, legislative interpretation or intervention, you should call it, is the cornerstone of certainty. And with that, I come to the subject matter. The statement which we are going to address today is updates on Indian taxation. So it is fundamentally an Indian-centric session. And if you see the updates in the last 3-4 years on the legislative side as well as the judicial side, there have been a series of developments which are critical and need to be analyzed and need to be discussed so as to result in more certainty. In the first session, there came a discussion about multilateralism being the new keyword of global interaction at this point of time. In fact, MLI or multilateral instrument, which came after from the BEPS action, is perhaps one thing which can be termed as a total success as far as multilateralism is concerned. Because anybody who's worked with treaties would know how long time it takes to even modify a single treaty. And through a single multilateral instrument, if I can modify 92, 95 treaties, it's a huge thing. But once MLI has come into picture and how it has to interact with our existing treaties, how we are going to interpret it, how there are differences in opinions. Those things are important. And in our discussion today, fundamentally, we are going to address two issues, and the panel chair will actually address and give a brief about these issues. The first issue is MLI. The second issue, which is actually a fallout of COVID. In COVID, everyone was working from home. Working from home within the same jurisdiction still did not matter too much from the tax perspective. But once I started moving out of the country, out of the jurisdiction, I'm unable to go back to the parent jurisdiction or my employer's jurisdiction. Then it naturally created a global mobility. And that global mobility, in fact, became a fad, a fashion. Post that, it was comfortable to stay in a beach house in the Caribbean and work for the US. So those things need to be worked out, and what implications do they have on the tax perspective need to be sorted out, discussed. And that is exactly what the glittering panel here will actually put their minds at. And chairing the panel, as the panel chair, is Madam Shifali. She is chairperson on the for Deloitte South Asia panel, and she's been recently nominated to the Permanent Scientific Committee of IFA, which is actually a very honored appointment. And she will take the panel through the next 80 minutes or so. We have Mr. Padam Kimcha, and he's a prolific writer, apart from being an advisor, and he's been teaching in a number of educational institutions. And that, in fact, will add richness to the panel and discussions. He'll share his experiences with us, and I'm surely looking forward to hear him. We have Amya Kunte, Mr. Amya Kunte. Everybody would have heard of Tax Sutra. He is one of the co-founders of Tax Sutra. And presently he's running his own enterprise as a partner, Globeview Advisors from Pune. And we have Shreya. She's a chartered accountant with a good experience of 17 years. And she's an expert in merger acquisitions, international advisories. And you look up who's who of taxation, and you can find her most of the places. I hand it over to Shifali to carry on this discussion forward. Thank you, ma'am.
Thank you, Mr. Chopra. And good afternoon, friends. Thank you for coming in for the session. I know it is difficult, but this is an intimate audience, and we as a panel are looking forward to discussing some of the latest developments in Indian tax. Again, it's an honor and a privilege to be back at the FIT, and in such a momentous occasion where we were also commemorating the founder, Dr. Professor Roy Rohatgi, as well as the 25th anniversary occasion for FIT. Many of us as international tax professionals have learned a lot at this foundation, and we will continue to give back to the society through this medium. I think today's topic for us is the multilateral instrument, and which is something that we thought that we'll take up in the context of the nuances on interpretation that are likely to arise. Because, while we've had tax treaties for, centuries now, but in terms of the MLI, it is really still very, very nascent. And we've not seen any court cases anywhere. So obviously we are doing a little bit of crystal ball gazing to see what nuances could arise. And it is interesting that, while for tax treaties that have been in existence for so many years, we are still struggling on the interpretational issues. And the recent, the MFN case is another one, where how to interpret the tax treaties, what is the relevance of notification and subsequent practice, all these issues are becoming relevant, even in a tax treaty context. Then multilateral instrument is one single instrument, which is, lauded as more of a consensus document or a consensus solution to all the bilateral treaties, which are all the covered tax agreements, and taking it more to a concerted action to prevent tax evasion. So how to interpret when especially, the countries have not come together to either notify or to come out with their versions of synchronized texts. What do you really make of those, the interplay of the MLI with the current set of tax treaties? What issues could arise out of that? I think it is going to be an interesting discussion. There is also, just looking at the history of it, there is a difference in practice. So, for example, the monist countries have a different practice as to how they have adopted MLI, which is, largely for them, once it is ratified, it becomes an authority and they don't need to do anything further. Whereas there are many other countries, the dualist countries, they have multi-step process for it. It is interesting where countries like Sweden, for example, they have to amend each of their bilateral treaties through the MLI, and then they have to notify the bilateral treaties for them to take effect. So there are practices which are different in different countries, and before we start applying or interpreting MLI, it is important for us to know why the practice is different in each country. Also, the different rules of interpretation. We don't have a rule set, right? I mean, we know that if there is any inconsistency between the MLI and the covered tax agreements, what do you look at? But what is the hierarchy, right? Do you still look at the OECD commentaries? What if, the OECD commentaries are subsequently amended? What is the relevance of subsequent amendment to the OECD commentaries to a covered tax agreement which has already been, modified on account of MLI? What if the countries come together and bilaterally negotiate further changes into their covered tax agreement? Through the bilateral negotiations, is it possible and is it open to the countries to make changes which may even take away from some of the obligatory changes that are required to be brought about through MLI? Again, an interesting discussion, up for debate. If we have, the time, we will, engage more into question answer format on that. But there is nothing that stops the countries from bilateral negotiations. The MLI is just a shortcut to negotiating all the bilateral treaties. But tomorrow, if there is any other amendment that is required, it doesn't stop the countries from coming together for bilateral negotiations. There are also issues about the language in which the MLIs have been adopted. I think the English and the French versions, what if there are any nuances? And this won't be the first time, whether it is the OECD commentaries, the OECD model. We've had instances where there have been those differences on account of different languages being used, where you interpret you refer to the same term in two different senses. Very subtle differences, but there could be. And then imagine more when countries go out and publish synchronized texts, which are unilateral synchronized texts, which do not represent any bilateral understanding between the two treaty partners. So how do you then interpret those synchronized texts? What is the legal authority of the synchronized text? And if the taxpayers have relied on it, can they still, make use of the theory of legitimate expectations? If the country has already published this version, and by relying on it, even though it may not be supported by the other country, can they be protected by the theory of legitimate expectations? So lots of nuances could arise. We could also discuss, the implications between GAR and MLI, while already, some discussions have happened, but how does one, interlay over the other? And while it is understood that MLI, being a multilateral agreement, and which sort of represents the consensus amongst all inclusive framework countries that have adopted. But what if there are countries who have not adopted this MLI? If there are treaties with those countries, or if there are no treaties, just pure domestic GAR application, could the principles from MLI be still borrowed by the local courts and applied in such situations? So lots of nuances there, but with that, let me invite my first speaker, Mr. Kincha, to come and talk a little bit about the MLI and the relevance of the supplementary documentation around it.
Before I begin, sincere thanks to FIT, IBFT for inviting us here to share our thoughts on certain important developments that are impacting all of us. And thanks to Shefali for wonderfully laying the outline or the background within which we are required to discuss certain developments that have happened today. From 2016 to 2023, 7 years have happened when MLI came into effect. Therefore, before we get into the technical nuances, it becomes also important for us to understand the impact that MLI has had today. Therefore, we need to pause and find out as to what the future holds for this MLI. And we can study that best by looking at certain statistics, both from an India level as well as from a global level. And those statistics are important in my opinion. For example, India has said 93 countries have been notified by India and deposited with the depository. But only 55 treaties have become a CTA today. So out of the total treaties that India has had, the dispute is about the number of treaties. If you look into the OECD website, it says about 98 treaties. If you look into IR's commentary on income tax, it talks about 126. But we are close to 50% only of our treaties becoming or turning into CTS. One. Two, at the global level, if you look into the OECD website, there are about 3,484 treaties today. OECD is saying that about 1,850 treaties have been impacted by MLI. Now, that may not necessarily be true because 1,850 represents those treaties that have been given to the depository. Out of that, how much have turned into a CTA? Only 1,231 treaties have been now recognized as CTS. Again, the statistics are pretty low in terms of the effectiveness. The way it began to say it's going to be a movement that's going to change the entire jurisprudence, going to change the canvas of international taxation, possibly in the 7 years of experience, we do not find that success rate to be high. And what's the reason for that also is important for us to look at. Because as was mentioned by Mr. Raman Chopra, we are having a lot of churning in recent times. We have had in the morning session talking about a new global framework of tax by the United Nations. They're going to have by 2024 a new model for international cooperation, which is going to be the base for a new regime of international taxation. We are having a UN MLI specifically and separately. They're going to have fast-track instrument to say that they're going to have a generic document. They're going to have protocols which will enable you to opt in and opt out. We have had the movements towards giving source countries the right of taxation by amending and by proposing new articles, Article 12A, Article 12B, now the UN amendment to, a proposed amendment to royalties to include software development. We've had the global minimum tax, we've had the Pillar 1, we've had the Pillar 2, we have had the US having its own regime of taxation. So we're now trying to grapple with so many things as a result of this pace of action at the international tax front. Possibly that measure, which was 6 years ago, is losing some sort of its steam. And that also is corroborated by the fact that India has entered into 3 treaties after MLI. China, we have followed the MLI model. But look at the treaty India's entered into with Iran and Chile. Not even an iota of wordings of MLI coming about it. Normal treaties, the way they were entered into. And the question therefore arises is, India itself, when its treaties latest, is not following the MLI guideline. Possibly they are focusing on the new development that have happened. And therefore, the political compulsions or the economic compulsions are overriding the legal compulsion of having a regime that accords with the MLI legislation. India's major trading partners still don't have an MLI. US, Germany, Switzerland, Mauritius. So therefore, significant chunk of economy is not happening. Even in relation to the balance of the economies, because of the mismatch of notifications concerned, significant provisions are not applicable. Therefore, the question arises, in terms of the impact on corporate behavior, we have not had significant impact for the reason that the scare or the need to abide by this is not visible for the reason that I have so many options available to me, but I can't bypass very elegantly the MLI itself. Therefore, we are looking at certain other new developments that are happening, and as a result of which, the corporate behavior and the fear in terms of MLI impacting corporate behavior has not achieved its desired purpose. This is one part of the story. Second was mentioned by the chairperson in terms of the recent decision concern and the notification issue. I'm not going to go into the merits of the MFN decision. I'm only looking at the significance of a notification and the context of that notification as far as MLI is concerned. Because Section 90 of the Income Tax Act says the central government has the authority to enter into a treaty, and it shall be, for the purpose of implementation, notified by the central government. So taking cue from Article 73, Article 253, and the list 1, 7th schedule of the Constitution, the Union Cabinet has the authority to enter into a treaty with another country. And that treaty requires notification for it to be effective. And the question therefore arises, as far as MLI is concerned, is there a need for a notification? Now this becomes interesting for the reason that it was the department or the government before the Supreme Court that made a plea to say that unless there is a notification, the treaty should not be given effective. And need to therefore ask this question in a different context now. That is there a need therefore for an MLI to be notified? Or are you going to make a statement that the MLI shall not be effective unless it is notified? For this reason, we have to go back to the parliamentary procedure that we had India signing this in 2017. Then it was approved by the Union Cabinet through the government rules of transaction business, Rule 12 there, approved by the Union Cabinet, sent to the President for signature on 31st of May 2019. So one way of arguing things would be that the internal procedures for notification have been complied with by India. But interestingly, 2020 Finance Act made a statement that we need to amend Section 90 of the Income Tax Act to borrow the philosophy of Article 6 of the MLI, talking about the preamble to the treaty is concerned. And post 2020, when the government did recognize the need for amending Section 90, we have had no notification given because entire procedures were complied with by 2019 May itself. And the question therefore logically arises, is there a need for you to have a new notification being issued post the amendment of Section 90? Or you're going to argue differently for the reason that Section 90 by itself has the aspect of avoidance of tax as one of the principal purposes of the treaty being entered into by India. And this avoidance of tax is a very strong word, takes into account the entire objective or the purpose of Article 6 of the MLI today, to say that this shall be the avoidance of double taxation, avoidance of double non-taxation, reduced taxation through avoidance mechanism. All this can be captured within the ambit of the avoidance of tax, and therefore there is no need for us to go into the aspect of a separate notification concern. But what's important for us to understand is that once there is some sort of a notification by the government of the MLI, and that becomes a standardized template on the basis of which a notification is given by the government concerned, and that notification matches with the notification given by the other country concerned, then a template becomes a bilateral agreement because of the matching of the notifications concerned, and therefore it becomes some sort of a binding document concerned. That becomes an interesting proposition, therefore, in terms of the aspect of notification concerned. But in my opinion, because there is a template drawn about the entire MLI as a canvas itself, and that canvas has had the approval of the parliament concerned through, and the president also accepting it, possibly one can make a statement that the internal mechanisms for the purpose of validating this has been accomplished by the government concerned. Therefore, there may not be necessarily a need for a new notification as far as each text is concerned. When you talk about this text also, there is also mention about the synthesized version. And therefore, is there a need for a synthesized version? The chairperson was mentioning very elegantly to say Sweden has a mandate. Some countries have a mandate. India does not have a mandate to say that the synthesized version shall go by the parliamentary approval process concerned. One. Two, the position paper for India is that it is an administrative action. It's a practical tool. It's some sort of a mechanism by which you can have a synchronized and uniform measure of interpreting a particular treaty concern. And to that extent, being a practical tool, there is no need for this to be a formalized document. And because it is not a formalized document, there need not be a case of issuing a notification in relation to the synthesized text concern. We have had some issues in terms of the version between India and UK not agreeing in terms of the synthesized version concern. How do you resolve that? Possibly, I'm not going to go into that controversy because there is some sort of a difference in terms of the perception concerned. But what's important for us to understand and acknowledge is, from an Indian perspective, there is no need for us to have a notification for synthesized text not being effective at all because it's only some sort of a practical tool. It's an administrative convenience than a legal reality itself. And coming into the aspect of how do you go about interpreting this MLI vis-a-vis a treaty, vis-a-vis a protocol concern, that again becomes a very interesting statement in terms of the legal background of how the MLI came into picture. Because the statement in the MLI says it has to be read alongside the treaty concern. It is different from a protocol. A protocol goes to change the text or the language of a treaty concern. An MLI does not go to change the text or a language. It has to be read alongside, indicating therefore that the treaty shall be one document which will have no freezing in point of time. It's a live document. There is also an MLI which has been entered into later on. And so the question is, two agreements are in place and the interpretation by Article 2 of the MLI Convention itself says that if there are two documents also confirmed by Article 31 of the Vienna Convention, that if there are two documents, the second one will prevail. The first one can prevail to the extent it is compatible with the second document. If it is incompatible, then the second document shall prevail, and therefore it will be a case where the MLI shall prevail over the treaty concern. This becomes very interesting for also from a different context concern, that one unique feature of the MLI has been the fact that the entire process has been in public domain. It has been in public domain in terms of the action plans, the explanatory memorandum to all the action plans, and thereafter coming into action plan 15 in terms of having a single document which now is going to be implemented for the purpose of carrying forward swiftly the BEPS mechanisms or the BEPS proposals itself. Therefore, these are some documents that are there prior to the execution of the MLI. Question therefore happens is, what happens to documents prior to the execution of MLI? Can they be legally taken into account for the purpose of understanding? And what happens to the commentary thereafter in 2017 commentary of OECD, which is based on this MLI document itself? Now, Article 31 and Article 32 of Vienna Convention are very interesting to say that a subsequent agreement and a subsequent instrument shall be supplementary means of interpretation. Therefore, possibly 2017 commentary is a subsequent document, can be a means of interpretation. What about the preparatory text? What about the action plans concerned? Action plans are preparatory work. Article 32 says preparatory work is important. The circumstances of the conclusion is important in understanding the context, and possibly therefore the preparatory work can help us in understanding the context. But possibly a little more status is given by the fact that if you look into the preamble to the treaty itself today, it says for the purpose of implementing the BEPS related measures for the purpose of and implementing swiftly and coordinatingly in a manner that all that has been come about in the 14 action plans, we are now changing. And therefore possibly the object and purpose of the MLI itself is between the action plan 1 to action plan 14 of the BEPS related project, which are giving you the insights into how to go about this process concerned. These action plans also give the suggested draft or changes to the OECD commentary. Therefore, what comes about later on is also in the context of this document concerned, said to be very relevant for the purpose of understanding. Therefore, the documents that are there earlier, that have been subsequently entered into, and the MLI, all these help us in understanding the context very well. In some situation concerned, they can also be spoken to as talking about the object and purpose of the entire document.
Mr. Kincha, would you like to comment? Do you see any implications this would have on the tribunal or the courts? Just looking at the whole documentation around MLI, the object and purpose, is there likelihood of any overhang, when they are looking at some of the cases?
We have had no exposition from the judiciary side as yet. To the extent of our public knowledge, we don't have any tribunal decisions also. Therefore, we are not too sure as to what are the ramifications of some sort of a stand taken by the department which is inconsistent with the stand taken by the SS. And that's bound to happen in my opinion. That's bound to happen for the reason that, as the chairperson was mentioning, this is a complex document. Reading the MLI along with the treaty text and understanding the mindset about how it went about is bound to give rise to a huge amount of interpretational issues concerned. Therefore, there's bound to be some sort of a disagreement in terms of there's going to be some sort of a difference of opinion that's going to be natural. Now, how do we look at courts interpreting that? How do we look at courts interpreting that? Are they going to be therefore be governed by strict legal rules of interpretation? The answer, to my opinion, would be yes, unless they find some sort of a difficulty in understanding the provision concerned. Then they can go back to the context. Then they can go back to the explanation that was attaching there. Otherwise, the law has to be read very literally. I understand these treaties are not the language of a technical person, but a language of a technocrat or a layman. It's like a diplomat who has done this language. To that extent, therefore, they may not deserve that element of that element of strictness. But largely, it has to be strictly interpreted in the sense that if there were to be a difference of opinion, possibly giving a go by to the background that has happened in terms of negotiating this treaty concern, may be persuasive, but not necessarily conclusive in terms of coming to a conclusion concern.
Thank you. So now what we've done is we've picked up 2 case studies on the MLI, and I invite Shreya to first talk us through the India-UK.
Thanks, Shefali. So, Mr. Kincha just alluded to the intense complexity of having 2 separate documents side by side and having to read them together. Since this example is a little involved, before I begin, I would like to offer a couple of propositions which I think are useful when we're reading treaties. The first is that there is a fundamental difference between domestic interpretive techniques and treaty interpretation. The reason for this is that a treaty is an agreement between 2 contracting partners. And so what is in the crux of that agreement is very important to understand. And if I could borrow or slightly morph something that Tolstoy said, all happy treaty partners are alike, but all unhappy treaty partners are unhappy in their own way. So in figuring out what is the source of this unhappiness, and I think this is true of treaty interpretation across the board and not just tax treaties. And the reason I emphasize this is that I think when we look at tax treaties, it's very important for us to take off our tax hats for a moment and think about what is the broader regime that we have in relation to how we approach treaties. And I think there are 3 questions that are useful to ask. The first question is, what did I agree to as a treaty partner? What does the text say? What was the nature of my obligation? The second is, once I figured out what I agreed to, how do I give effect to this obligation domestically? And that's also been alluded to briefly by the chairperson and Mr. Kincha in terms of dualism, monism, do you need a domestic notification, and so on. So that's the enforcement piece. And the third is, and related to the first 2, maybe not an entirely separate question, but where it's a gray area, where I'm not able to come to a conclusion. To what extent should I pay heed to what my treaty partner has done? So to what extent is their behavior determinative? Now, the reason I lay these down as building blocks of how to approach a treaty is because I think they help guide our response in tricky situations. And this case study that I have before you is one such situation where there clearly is a difference of opinion between treaty partners. And so how should that guide how we read the treaty and move forward? So I've taken the liberty of putting up the text of the treaty on the slides so that all of you can also walk with me in terms of what the issue is. So you see here Article 7.1 of the MLI, which contains the principal purpose test. And if you see the red highlighted language, what it says is that treaty benefits can be denied if obtaining the benefit was one of the principal purposes of any arrangement. Now there's a catch here, and the catch is in the second part of the red highlighted text, which says that if the purpose of the arrangement or the way in which the benefit is granted was in accordance with the object and purpose of the treaty, then benefits will not be denied. So I'm going to refer to this as the carve out when I look at the remaining provisions, right? So 2 points to take away from 7.1. First is there's a principal purpose test. So if obtaining the benefit was one of the principal purposes of putting in place an arrangement, then you can no longer rely on that provision. But if the way in which the whole arrangement was put in place was in accordance with the object and purpose of the treaty, then 7.1 will not interfere, right? So this is the carve-out provision. Now, if we could go to the next slide, and my apologies, this should read 11.6 of the treaty and not the MLI. What you see is that in some treaties, and this is specifically in the provisions relating to royalties, interest, dividends, for instance, you also have principal purpose tests. And these were in place before the MLI was put in place. So they're in treaties as of today. And if you see the language, and I've highlighted it in red again, there is a reference to the main purpose, or one of the main purposes of the arrangement being to obtain a tax benefit. But as you will notice from this provision, the carve-out is missing. So the object and purpose carve-out that we saw in 7.1 is not there in 11.6, for example, of the India-UK treaty. So the question that then arises is, and keep in mind what Mr. Kincha said about reading these two agreements together. So they're both in place today. So which one do I give precedence to? And there is some guidance on that, and I'll show you the language on the next slide. This is contained in Article 717A of the MLI. And 717A has two components. So I've only highlighted one in red because that's what I want to focus on. But if you look at the first part of 717A, it says that where two contracting states have notified certain provisions, then whatever they have notified will take precedence. So, for example, if India and UK had both notified 11.6, then it would be very clear what would take precedence. Now, in practice, what has happened is that the UK has specifically notified 11.6, for example, but India has not. And so the question that then arises is what happens under 717A? And that's where the red language becomes relevant. Now, what the red language says is that in situations where there is no notification by both contracting states, which is in other cases, this paragraph 7.1 shall supersede the provisions of the covered tax agreement, but only to the extent that those provisions are incompatible. So now let me just lay out again what we've sort of gone through. So you have 7.1, which has a principal purpose test with a carve-out. You have specific provisions in existing treaties which don't have a carve-out but which do have a principal purpose test. And then you have 717A, which says that if both countries notify, then whatever is notified will prevail. But if both countries do not notify, then 7.1 prevails, but only to the extent that there's an incompatibility. Now, what do we end up with here? The main question that we're ending up with here, and in the UK treaty, this happens specifically in the context of 11.6, which relates to dividends. You have 12.11, which relates to interest, and you have 13.9, which relates to royalties, and all of them say more or less the same thing, which is that if the arrangement was set up specifically to claim a particular benefit, then the benefit will not be available. But there's no carve-out. Now, what happens in this kind of situation where the India-UK treaty has these three provisions and the MLI has 7.1? What happens is that it all boils down to this question of incompatibility with the objects and purposes of the treaty. Now, the difficult part about objects and purposes is, and I used to teach tax at the National Law School for many years, where we used to deal with treaty-related issues. And I can give this to you in writing, that if you open this question up to a bunch of law students and said, what are the objects and purposes of the treaty? If you had 60 people sitting in a room, you would probably get as many answers. And the reason for that, the sort of ambiguity that arises, is because if you look at the objects and purposes of the India-UK treaty, for instance, there are two objects that are mentioned very clearly. One is that the treaty relates to the avoidance of double taxation. So that's one of the objects. But there's also a reference to fiscal evasion. So the treaty wants to prevent situations of fiscal evasion. Now, what happens in a situation where the same provision both avoids double taxation, but can also create situations of tax avoidance? So is it in sync with the objects and purpose, or is it not in sync with the objects and purpose? I think what you'll find when you start looking at this question of what is inside, what is the content, what is the core crux of the objects and purposes of a treaty, you will find a lot of ambiguity and a lot of disagreement in terms of what is going on. And so, what that does is you have centered the whole of 717A on incompatibility. Incompatibility rests on objects and purposes. But what is an object and purpose is something that different people can have different views on. And so the situation that you end up with is, do you say, so there are two possible outcomes here. One possible outcome is that you say 7.1 will prevail because that's what 717A says. But the other equally possible outcome is that when India does not notify 11.6, for instance, it does not see 11.6 as being incompatible with 7.1. The reason I put forth these two views is because I think, at least based on the text of the treaty, both of them are equally possible. And the reason they are equally possible is because 7.1 is a more liberal provision as compared to 11.6, because it gives you that carve out. So, what that means is if you satisfy 11.6 per se, then the likelihood that you will also satisfy 7.1 is very high. And so, the way I would read the way this has panned out, at least in the India-UK context, is the UK has notified these specific provisions, India has not, and the structure of 7.1, 717A, and existing material in terms of how we look at incompatibility would get us to a position where both requirements need to be met. But that being said, because the language in the treaty is already quite broad, the likelihood that if you satisfy 11.6 that you will also satisfy 7.1 is quite high.
Thank you, Shreya. Ameya, to you for the next case study on India-Singapore Treaty.
Thank you. Thank you, Shefali. Mr. Kincha gave a nice perspective around how many treaties are impacted, and he also mentioned that in the context of India, a few major trading partners, the treaties are really not modified. UK is one example where treaty is modified, and another example is Singapore, where we do receive a significant foreign direct investment. I just want to lay down the context to the India-Singapore Treaty just for reference, and then bring the MLI consideration as well. Before 2017, the treaty between India and Singapore provided for a exemption from taxation of the capital gains in the source state. So if a Singapore resident were to sell the shares of the Indian company, the capital gains were allocated to the Singapore and India did not have a right to tax. In 2017, Government of India modified the India-Singapore Treaty, and two specific clauses were introduced in the treaty. It's Article 24A. One suggests a concept similar to the principal purpose test or the anti-avoidance rule, and which is appearing on the slide. The affairs were arranged with the primary purpose of taking the advantage of the treaty. That's clause A. And then clause B was a specific anti-conduit clause, but it also subsequently provided an expenditure-based threshold. Now, this was a specific negotiation or approach by both the parties, that is India and Singapore, and this change came into effect in 2017. India, along with Singapore, also modified the treaty with Mauritius around the same time, and Cyprus. So it was a conscious treaty policy. Around the same time, exactly, the MLI was being signed by the parties, 2017. And now we have a principal purpose test also being included in the MLI. Interestingly, unlike the UK situation where there is a difference in understanding between the treaty partners, in this case, both India and Singapore have notified each other, so it's a covered tax agreement, and also the Article 7 of MLI dealing with principal purpose test has also been notified, which means that MLI TPT takes over or would sort of supersede the 24A, the specific clause which was negotiated by India and Singapore. As Mr. Kincha outlined the interpretation approaches, a specific language inserted by PPT, which is a later point in time, would sort of oversee the tax treaty. And to that extent, the MLI language now is clear. But just taking a pause over here, Shreya showed a carve out in Article 7.1 about the object and purpose. Like I mentioned to you, the specific change in the India-Singapore Treaty happened around the time when MLI was being negotiated, finalized. Both the treaty partners took a specific call and provided a grandfathering for investments made into India from a Singapore company before 2017 and provided for a capital gains exemption provided conditions of Article 24A are also met. And to that effect, therefore, the proposition is that in this case, would you look at the object and purpose to grandfather pre-2017 investments and not apply the PPT? That's really the proposition. Here, like I said, both India and Singapore have notified an ideal.
They are looking at the new object and purpose.
Sure.
So the old object and purpose has already been grandfathered.
Sure. Of course, the ideal thing would have been both India and Singapore around the same time make a specific carve out for this proposition. And I must say that around the same time, even Cyprus Treaty is modified. It's also a covered tax agreement, but there the context is slightly different than the Singapore Treaty. Point one, and point two, maybe the issue that I highlighted is on a very practical level. As Shefali mentioned, if I meet both 24A, both the clauses, will there be a situation left which will meet these anti-avoidance provisions and fall out of MLI? Of course, here it is a primary purpose, whereas PPT suggests one of the purposes. So to that extent, PPT is more stringent. So this is an example around India-Singapore Treaty.
So what is clear, Ameya, is that we are going to have as many objects and purpose as the treaties. And, no matter what we do, I think even if there is a single MLI, when you adapt it to the, each of the covered tax agreement, we are going to end up with a different situation. What's also important is that this trend of how we are really applying and interpreting the treaties is also going to have an impact on the other things. So, for example, on the treatment of fiscally transparent entities. We've got in some of our treaties, we've specifically covered how we will deal with the fiscally transparent entity. In MLI, Article 3 specifically says that if the income of that fiscally transparent entity is taxed in that state, either in the hands of the entity or its shareholders, then it is still to be treated as a resident for the purpose of tax treaty. But then India has expressed a reservation on that. So now we don't know whether, the history that we've had on how we will deal with the fiscally transparent entities, including, also the judicial pronouncement in the case of linklators, whether that would have any continuing applicability or we will now have to look at everything with a new lens. So interesting times ahead. But with that, let's move to our next topic, which is on the mobility. And this has stopped working, just in case.
Not mobile.
Yeah. When we talk about the digitally mobile people. So we are next talking about the global mobility of individuals. I think post-COVID, we've seen that there is already a lot of mobility amongst the working group. And it is, I think generally there has been a lot of flexibility given by the corporates to the employees to work from home or work from anywhere. And what this has led to a lot of complications, not just for the corporates, because where all they might have a digital presence in some form or the other, but also in the form of taxability of the employees themselves and a lot of other implications. Deloitte has a study on what is the future of work. And what it says is it is going to be largely governed by the 3 Ws. The first one being work, which means, what work will be done, what will be automated. We already have the ChatGPT and the other options versus what will be done in terms of the actual workstations. The second one is who is the workforce? And again, this is the classic debate versus men and machines as to, who are you going to count in as your workforce, where a large part of your work is done by machines and not by actual human beings. How are you going to allocate profits to the physical presence? And the third one is where is your workplace? Now, the way the technology is getting transformed, it is going to give rise to newer business models, and it is going to transform the workplace as we traditionally understand. So with that let me now invite Shreya to talk a little bit about what is the global development on the mobility and the case laws around.
Yeah, thanks, Shefali. So this is an area that's very close to my heart. So much so that last year I committed to investing 7 years of my life towards a PhD on this area. So I think there's a lot that can be said. We have 5 minutes, so I'm going to do what I can. I think, again, two key sort of observations on this. The first is, if we look at how tax policy has evolved over the last 10 years or so, but really since the beginning of time, I think it has proceeded on the assumption that firms and capital are mobile and individuals are less so. And there are many examples of this, right? So if you look at the importance that has been given to the market with the digital taxation, and very rightfully so. If you look at individual decision making as a proxy for corporate value or as a proxy for the residents of overseas entities, these are all based on a sort of assumption that individuals who are decision makers are likely to be less mobile than corporate entities or capital, for instance. I think this was true for a very long time. But with COVID, what has happened is that there's been a seismic shift in terms of the future of work. And I was just looking at some statistics, and Yvette was, I think, talking about it earlier today as well, where she talked about the BlackBerry example and what it's meant for the future of work. But I was looking at some statistics in terms of how employee preferences have changed post-COVID. One study says 82% employees want to work from home or at least have a couple of days working from home a week in India. As per a Forbes study about global work preferences, 65% of people want to either work from home or be digital nomads. And the most conservative study I saw, which was in the US context, said that by 2025, 25% of the workforce would not be working from the location. Now, when you think about what this means for tax policy, it blows your mind at some level. And the only parallels that we have were COVID time parallels. And I think the OECD, when it put out its response in terms of how the COVID circumstances should be addressed, they were at pains to emphasize that this was a temporary measure and it was due to the extraordinary situation that was arising in the world. I think what tax policy is yet to do is look at how thinking about work has changed post-COVID. And I gave you some of those statistics. Now, in India as well, the response was again very targeted to COVID. We did give relief for people who were stuck here, but we've not really, I don't think there's been a lot of thinking in terms of what's going to happen in the future, although that is a conversation that is starting to begin now. What is interesting over the last 1 or 2 years, and Mr. Kincha and Amya, I think, will deal with this in the Indian context, but we have seen cases from some other countries in terms of how existing tax provisions, and I'm talking here specifically about PE provisions, although these issues can come up in some other contexts. So how PE provisions should arise in a remote working context. And I'll give you 2 cases because I think they indicate the issue that is at hand and how responses can be different. So there's one case, which is a Spanish case from 2022. And the facts of the case are as follows. There was a UK company. It had an employee who relocated to Spain during COVID. He decided to continue staying there. He didn't want to go back. Now the company wanted to retain this guy. So it said, okay, fine, you can continue to stay where you are. We're not going to give you any additional money. We won't, enable you to set up an office and so on. You will continue doing what you were doing when you were in the UK. It's just that you can do it while you're sitting in Spain. Now, this case came up before the Spanish tax authorities. And even though this person had been in Spain for a very long period of time, they came to the conclusion that there was no permanent establishment. And this was quite surprising to me, and I'll give you the reasons that they've given as well. So first, they've said there was no fixed place of business for the UK company in Spain because the home of this employee, where he'd been living and working out of for a very long time, was not available to the company. And the reason it was not available to the company is because staying there was a unilateral decision of the employee. The second, and bear in mind what I'm saying, because when we come to the Danish tax authorities, they come to very different conclusions on what I think are very similar grounds. The second observation was that the company did not require the worker to be there. It was entirely his choice, and therefore his being there could not be considered a projection of the company in Spain. The third is they relied a lot on how the company did not pay for the expenses of this worker. And fourth is because of the specific functions of this worker, he was found not to create a dependent agent PE. So he was not doing any sort of decision making or signing on behalf of the entity. Now, in the same year, just a couple of months apart, there's a case, a Danish case, where a German entity had a Danish employee who went and settled down there. He was engaged in a sales position, and again, it was entirely driven by him. The company did not need him to be there. It was not doing active sales in Denmark. I think they had vendors in Denmark who constituted about 5% of their overall activity, but no sales. He was traveling for 50-60% of the time, so he wasn't even in Denmark throughout. And he had no contact with customers in Denmark. So again, the company was not making any revenue from there. He was staying there of his own accord. The company was not funding any of it. But the Danish tax authorities said that there was a PE. And the reason they said that is because there was a workplace at his disposal. The employment was not time limited, and it was continuous and long term. I think these two cases are interesting to look at because even applying the provisions that we have to very similar situations, we see how authorities can land up at very different conclusions. And this is only scratching the surface. And before I sort of hand it over to Mr. Kincha and Ameya, I do want to point out that in the last meeting of the Inclusive Framework in Paris, which happened in September, they specifically picked up on this issue of global mobility, and they specifically talked about 4 categories of mobile people. The first is workers. So employees who are employed with one company and relocate to another country. And these are in ascending order of complexity. So workers is actually the most simple of it. The second is pensioners. So people who have worked in the past and then relocate to another country to retire. And therefore, social security, pension payments, any kind of deferred payments like equity incentives, all of those start becoming complicated. But on the first 2 categories, we do have some guidance because these are issues that have arisen in the past. The third category, and again, Yvette spoke about it in the morning, so I won't get into it more, digital nomads. And I think Ramanji referred to somebody who wants to go and live in the Caribbean, for instance. So that's a classic case where very highly talented employees now have the option to go and live wherever they want and work with these entities. And so what does that mean for the tax system? And finally, you have high net worth individuals. And the numbers here in terms of how many individuals is not big, but the wealth is huge. So HNIs, the super rich, what happens when they relocate and you lose the right to tax them? I think going forward, a lot of these issues are going to really get amplified.
Mr. Kincha, over to you. I think you have a few case studies to talk about. And if you had a similar situation in India, how would the Indian administrators view it?
There are 4 different scenarios that we need to discuss. This is a very elementary way of presenting. You could have many ramifications or associated complications at that. Question is about from the angle of the company, whether there will be a permanent establishment. From the angle of the company, whether there will be a place of effective management so as to change the residence of the company to another jurisdiction. And third would be the aspect of the taxation of the employee itself, who is now working beyond the jurisdiction that he was normally accustomed to living in. He has gone to another jurisdiction and overstayed there for whatever reasons. The question, therefore, is the first one is about a software engineer who is very at the lower rung of the ladder concerned, who is an ordinary worker of a company concerned. What happens if he is working for a long period of time at another jurisdiction concerned? The next case is the case of a divisional head. Is a CTO, Chief Technical Officer concerned, or a Chief Technology Officer concerned of a company, and who is overseeing a particular development center in India. Not a global responsibility, development center is being taken care of by him. Third would be a global head of marketing and sales who is looking at the global sales itself. And the fourth would be a founder and a board member. And these are all 4 people who are staying differently at a different location. And the question, therefore, in the context would be, what shall be the tax implications attaching each of this? Before we go into that, we'll look at the way Shreya has made a mention about where I will have some sort of a control, or I should have some sort of a control over the place where my employee is working. That is called as a right of disposal test. Only then the company is said to have a permanent establishment. And that right of disposal test should happen as a result of the company itself requiring the employee to use that premises concern. If the employee says, I'm using it on my own, the company not having a requirement to make him work from there. For example, the company provides an office to an employee, but he wants to work from home. Question therefore would be that the company has an office, fine. That can be a case where I look into the aspect of permanent establishment, but where a person is working from home, despite the company providing him an office, what will happen? And as Shreya rightly pointed out, the outline given by the OECD is confined to the COVID period, should not be naturally extended to where a person is out of choice saying, I would like to stay in a particular location. Therefore, the question for us would be, there can be a permanent establishment of a fixed place of business, carrying on business through that permanent establishment for a reasonably long period of time, could be one. There could be an agency permanent establishment where a person who's at a particular location has the habitual authority to enter into contracts or plays the principal role habitually, which leads to the conclusion of contracts. You can have a dependent agency P relationship. Third could be a construction P or a supervision P where these activities are being carried on at a particular jurisdiction for a reasonably long period of time. And from an Indian context, you could also have some sort of a service P in particular treaties concerned, where from a particular jurisdiction you are rendering services through your employees or other personal concern, you could have a service P. Now, in all these four situations concerned, where there is no compulsion for an employee to be located in that country, he can move out voluntarily, but he continues to stay there, and he's continuing to stay there for a reasonably long period of time, then possibly these four permanent establishment situations can get attracted, and therefore the company would be liable to pay tax. One interesting question that comes around in this context is, let us say there are 50 people or 80 people or 120 people who are working from their different respective homes concerned. Would there be 120 permanent establishments? Are you going to make a statement that there has to be some sort of a commercial coherence as also geographical coherence for you to have some sort of a permanent establishment? Commercial coherence can be established. Geographical coherence cannot be established in this 120 jurisdictions concerned where employees are working. And therefore, there's going to be some sort of a relook in terms of this coherence aspect, giving rise to a permanent establishment. But the fact is that there is some sort of a business being carried on, and for a long period of time, at the choice and voluntarily by the employee concerned, as a result of which the head office is making profit, they should give rise to a permanent establishment. Two, but as far as the place of effective management is concerned, interesting to look into the Indian guideline on this matter concerned, where they're looking at a situation where we don't look at the place where the board of directors meet. It's a place where the senior management looks into, where the senior management who are involved or relevant for the purpose of taking key strategic decisions, where are they meeting? Where are they taking their decisions concerned? Not the place where they're implemented, but where they are taking these decisions concerned. And in the Indian context, the board circular says a divisional head can be a senior management, and therefore a CTO or a sales director concerned can therefore assume the role of a senior management, and his role at a particular place can be therefore important in terms of determining whether there is a sort of a effective management. What's important for us to understand is the commentary talks about still a harmonized, coordinated way. We're looking at the substance of a decision-making process, not looking at an individual concern in terms of taking a decisions. That means the commentary talks about not necessarily a place of management, but a place of effective management. A CTO by himself may be a place of management concern, but he may not necessarily constitute a place of effective management because you're looking at some sort of a harmony, you're looking at some sort of a coordinated efforts concern. Therefore, place of management can give rise to some sort of a permanent establishment by itself under Article 5.2 or 5.3, but may not necessarily or invariably lead to a place of effective management. And that's an important aspect that I look at little more than an individual concern for the purpose of making a statement that there is a place of effective management. Therefore, a software engineer, no question of this is leading to a place of effective management, no poem there. This person, global CTO, does contribute, but we have to look into the overall context concern to say whether this person is going to give rise to or going to contribute significantly to a place of effective management. Although on a standalone basis, in my opinion, he cannot give rise to a poem on a standalone basis because he works in a larger organization where there is some sort of a coordinated action required, and particularly in the situation concerned, that he is overseeing the development center work in India concerned. It's also important that from the employee's point of view, look at the taxation position, his residential status can become critical. One. Two, his salary, we are all very clear to say that today's salary is taxable because of the place we are performing or exercising our employment concern. But what's important is the case of retirement benefit. Pension can be an issue, can also be a situation where your deferred compensation plan like ESOPs can be an issue. They're trying to get around to a situation concerned that pension should not be linked to the place of where you're performing your services, because you are working in about 15, 18 jurisdictions in your life and you're getting pension at the end of it. Are you going to then allocate pension to 18 jurisdictions concerned was a difficulty that the OECD had envisaged, and therefore they said we should have a different rule for pension, saying that pension is taxable at the place where you are a resident beyond your time of retirement. We don't have such a rule or such a conviction in terms of ESOP plans concerned, and therefore, if you're getting an ESOP, they're exercised later on, and they therefore are referable to or relatable to various jurisdictions where you have performed your services. We may have some difficulty in allocating that ESOP to the various jurisdictions concerned, and that difficulty can get compounded by the fact that different countries may not necessarily have a uniform point of taxation. Some can have at the point of grant, some can have at the point of vesting, some can have at the point of exercise, some can have at the point of sale itself. Therefore, there could be a complication attached to ESOP taxation because the points of taxation are different, and you may be in a different jurisdiction at the point of happening of these events concerned, possibly inviting multiple taxation or possibly saying that I was not in the respective jurisdiction where the events are happened, therefore I don't have a tax liability at all. Then you go back to Article 6 of the MLI to say, I shall not allow MLI to be a tool for double non-taxation. Possibly under that jurisdiction, the employer will have to meet the proposal of the preamble to the model convention or the principal purpose test to the model convention.
Thank you, Mr. Kincha. Ameya, would you like to talk specifically about the last two use cases?
Sure. Before coming to that, in a CTO kind of a role, they are also contributing to the research and development, which may lead to the creation of intellectual property. And that has an important bearing from a transfer pricing point of view as well in the DEMPE. And we'll not touch upon that, but I just wanted to...
Sorry, just on that one, I think if there is a development center which is doing this R&D, arguably that would be owned by an Indian legal entity, right?
Oh, sure. So the point is that we are talking about the role of a CTO who's actually conceptualizing the global development and also the India Development Center. If otherwise it's a development center, then clearly there is no problem. But this was one point. And since Mr. Leonard is here, I thought all the issues that we are listing out here on the work from home, maybe UN could take this as a pillar 3 or pillar 4 consideration. So anyway, coming to the global head of marketing sales, again, work from home. So we are looking at a situation where a global company doing global sales, and it just happens that their head of marketing is based in India. If it is for the India market, then of course there are direct permanent establishment related considerations. But we are looking at a country of residence A selling to a customer in country B. The global head of marketing CTO who's driving the marketing strategy sales is based in India. In that case, again, at least the Indian domestic law is concerned, it would create some sort of a business connection, which is very, very wide terminology. Point one. Point two, when you look at the tax treaties, again, today most of the tax treaties which are not impacted by MLI, you will still apply you will still apply the place of disposal test as Mr. Kincha articulated. There is also the angle of agency PE, and to what extent is this global head of marketing driving only the strategy or actually involved in the execution becomes very, very critical to decide whether there is a permanent
So
establishment.
what is more critical, strategy or execution?
Strategy is more surely is more critical, and I
So
was
what if he's done the strategy while he's overseas and then he comes to India and does execution?
sure. So fair point, and which is why in the context of place of effective management, the senior leadership could be based in India, but where those decisions are taken. Now, there could be situations, as has been happening for many years, where board formally meets at a particular jurisdiction and takes a decision that would become effectively relevant from a POEM point of view. But from a PE point of view, if that person is taking these decisions and remotely, one situation, and two, executing those decisions, there certainly is a permanent establishment consideration which becomes relevant. It would exist. Moving to the founder or a board member kind of a scenario, again, there are two aspects. One is that there is a functional role that this founder or a board member would perform, and depending upon that functional role, the additional considerations will trigger. Per se, a board member present in India would not per se trigger a TE, but it would create a residency related considerations, and the place of effective management in case of board member becomes relevant. Just touching upon the head of marketing kind of a role, Shreya mentioned the rulings from Spain and Denmark. There's an interesting guidance I saw from Sweden in 2022 in the context of sales, and it in a way codifies the principles that you articulated, that is the employee working remotely as per the will and the requirement of the employer, or is it as per his or her own wish? And that is a key aspect, and where it is.
So just if I may interject
Sure,
here.
sure.
So that again takes us back to the object and purpose as to whose will it is.
Sure.
And how best can we infer? Is it something that is documented? Is it something that is shown? And does that mean that we will see a lot of documentation of the intent and at whose volition, this arrangement was put in place?
Sure.
Especially in the context, if you have a concerted action from, say, Amazon to place 50 of its people in a tax haven to work there. So if it is a concerted action, maybe you can actually attribute it that some profit needs to be allocated to that region or maybe India or whatever. So you have to, intent and purpose is very important. That is what he was in fact articulating.
Sure. I have a couple of comments to add, but after we complete the personal tax perhaps. So
I think Mr. Kincha has covered some of the
he's
personal
already covered.
tax.
If there's anything incremental.
Just one incremental point is withholding obligations of the employer. So aside from all of these issues which are up there on the slide, I think the struggle that's going to be there is that when an employer has to withhold, and there are all these mobile employees, digital nomads and so on, you have firstly a challenge of information. So you don't know where they are or if their residency claims are what they are. Even if you get over that, what do you do in a situation where there are potentially multiple in various places? You have to factor in what are the obligations in each of those places in terms of withholding. So for example, some countries give deductions for work from home, whereas others don't. So the complexity of complying with some of the withholding requirements because of the mobility could potentially become quite a lot. Also, just an ancillary comment on the objects and purpose. If we start documenting, and if we're looking at what is the objects and purpose, trust me, you put 10 lawyers in a room, it's going to be quite, they'll have a field day with it, I think. I think it's going to be very difficult to get to objective lines with that one.
Amir, did you want to add anything?
Yeah, sure. So, the social security, which is the last bullet on the slide, just a couple of practical examples already happening in the Indian context. There is a tax called a profession tax. It's a tax levied by the state government for an employee working in a particular state. And today, in the case of technology companies, it's very, very commonly happening. Let's take a situation where a company based in Bangalore, Karnataka, has an employee, let's say, working in Mumbai remotely. Where do you comply the profession tax? Is it the state of Karnataka or is it the state of Maharashtra? The similar problem gets extrapolated to the cross-border situation, particularly for the social security. I saw a couple of interesting examples. There's a specific agreement between Switzerland and Italy, which becomes effective from January 2024. And this is on the tax treatment. And they have given that if the work from home kind of a situation happens up to 25% of the working time of the employee, then no questions asked. And I saw a EU framework on social security where they said that up to 50% if the employee is not moving, we are okay. So like an indirect transfer, we may eventually see some percentages between 25 and 50 to decide when to trigger any of these implications.
On the social security, we have also the totalization agreements happening, and that's important for us that there are cross-border totalization agreements, how they give relief from social security obligation, and therefore that will also have to be more in mind when we discuss about the social security obligation.
So we may have time for one or two questions from the audience. And while you're thinking, do hold your questions. I just want to first raise some question and, to Mr. Chopra, and then, we can then invite the questions. So please think about the questions you want to ask. We've seen, there are some guidances, right, in other countries and where they are specifying certain amount. Now, it's not the best of everything. Yes, you're not going to try your luck and see what you get at the end of it. But there is an objective framework where you are saying that, okay, if you spend a certain number of days, or if you've, your certain allocation, whether it is for social security payment. Mr. Chopra, do you think in India, do we have a scope for something like this, where we may expect at a future date, some clear guidance from the administration, so that, as a taxpayer community, we are better equipped to plan our affairs and even comply with it? Because in many of such cases, as Shreya mentioned, we don't have information. The companies most of the times do not know. Absolutely. But I think now that this is becoming more of a requirement, and today the global employment models are changing so much. More and more, all the routine work is being pushed down to the computers, right? And all the higher end work is being done by those individuals. And whatever flexibility they need, the companies are willing to roll out the carpet. Yes. There is this global work from anywhere policies, which are also now, commonly heard of. And in such a case, how do companies make sure that they are fully compliant of all the local regulations, whether it is registrations, P declarations, withholding taxes? Are we likely to expect any guidance?
There are two parts to your question, ma'am. First of all, with reference to, there has to be a mechanism with the company itself to actually know where their employees are presently, and that mechanism has to result in a reporting framework, a compliance mechanism for the corporates that my employees are working in jurisdiction A, B, C, D, Z, and that has to become a structured framework. Once that is in place, the second part is whether we can do anything to provide certainty. So, as far as domestic law is concerned, yes, maybe we can consider it at some point of time when the stakeholders or the local domestic companies feel that this needs to be done. Maybe we can work it on a domestic tax framework. But as you are aware that we cannot unilaterally interpret the treaty in such a manner which overrides the provisions of the treaty itself. So we can give a guidance, but if it is contrary to the treaty, it carries no meaning. That is how I look at it. Maybe domestically, once it comes, then it peters down into treaty. That is the way forward. Yes, we need certainty. I'm sure of that. Thank you.
Dhruv, sorry, you had a question?
Thank you very much. First of all, congratulations on a fantastic panel discussion. I think it was very inspiring. It did it very lucid and very in-depth as well. I have one comment to make on principal purposes test, and if time permits, another one on place of effective management. Shreya, you mentioned that the second part of the PPT in 7.1 of the MLI states, unless it is established that granting the benefit in these circumstances would be in the objects and purpose of the convention. But actually, it is not the object and purposes of the convention, but the relevant provision of the convention. So if you're looking at Article 10 or 10.3 or 10.6, you need to look at what the object and purpose of Article 10 was, not the convention on a whole. And that is really where the challenge lies. where do you deduce the object and purpose of every single provision that you're looking at from? Someone could say, oh, the commentaries. Well, that is an issue in itself. I would say, well, maybe the history of the article, but maybe the historical object and purposes might have evolved as well. I think overall you need to deduce the object and purpose of a provision from the language itself, applying the rules of the Vienna Convention. And I think that is indeed, as you say, it is a level of complexity, perhaps beyond what you had also presented. It's not the generic object and purpose. Coming to Padam's point on place of effective management, place of effective management, you're right. When the notification or circular came out on the interpretation of place of effective management, I think it is also useful to bear in mind that place of effective management in that context was in reference to the domestic reference to place of effective management under the Income Tax Act. The place of effective management as used in the treaty, even though it is exactly the same term, could have a completely different meaning. And I think to all my students that I teach around the world, I say, please pay attention to the first 5 words of every definition clause that exists in a treaty. And those first 5 words are for the purposes of this convention. So the same term under domestic law could have a completely different meaning than it could have for the purposes of the treaty. They operate on parallel planes. They don't necessarily interact. This is perhaps a situation in which they could interact, insofar as place of effective management is not a defined term, and 3.2 would say, well, look at your domestic law. But then again, unless the context otherwise requires. So even if place of effective management has been defined under domestic law, I would say having a CT or a place of management has been defined to mean place of effective management. I would say the treaty context, given that historically there has been a very specific meaning added, i.e. the board of directors meeting, I think that would apply for the purposes of the treaty, and the domestic meaning will apply for domestic law purposes. Sorry for the very long comment, sorry. Thank you very much.
Thank you for that. Are there any other questions from the audience? Okay, in that case, I think we are ready to wind up our session. And I must thank all my panelists. I think they've done a brilliant job of bringing to the fore all the nuances in the MLI interpretation or the global mobility, the issues that are likely to arise, and especially in the context of what is the international commentary and the likely, Indian way of interpreting them. With that, may I please invite the chairperson to give his concluding remarks.
Yeah. We've had an enjoyable session here, and I've been elucidated a lot on the views presented forth by the panelists. I hope you've also enjoyed it. And it was indeed a very, very involved subject which we were talking about, and knowing the actual stakeholders' position is very important from the government's perspective also, and it is important from the stakeholders' perspective also, that the government has been conveyed some positions which might change as times go by. So we all hope that we all work towards a better future, and certainly. Thank you.
Thank you. Thank you.
Thank you so much.
Well, ladies and gentlemen, we'll now have a tea break for half an hour. We'll be reconvene at 4 p.m. Thank you.